I'm not muted. Hello, everybody. Happy Saturday. Let me get it up. Top chat reminder for everyone and mute reminder. Let me do that. Yay. Hope everyone is having a good weekend. I am behind in recording the second half of the ruling. And so that will be going up. I'm going to have have my production assistant / husband conjoin two separate recordings into one because the animals don't like me today. And apparently they had a lot to say about the second half of the order that we were reading. Yeah. Did you lock Kenny upstairs? Mm-hmm. So say Kenny's not with you. That's weird. So before I get off into this, by the way, just kind of first time live over here on the channel since Lisa Marie passed away. It was very shocking news. She's very young, 54 still. Aiden, for several years in a row, performed summers out at Graceland and at the guest house at Graceland, which is the hotel there on site. So we have friends and, and just a big prayer out to her family and her fans, and of course Elvis fans. It's just it's too bad. Between her son and then just 2 years later her, it was sad news. So before I launch into that, I just wanted to say that and say our hearts are with our family and friends out in Memphis. So the first discussion we had on this was really more about Rochelle Neese and her testimony and the testimony of those that were called in the habeas evidentiary hearing for Scott Peterson. That was rectifying out whether or not he would get a new trial. Because this happened at the end of last year, most people already know, of course, that was denied. So if I'll put some cards at the end to the audio read-throughs of the document itself and also to that first discussion, but we're going to talk more about the law and the legal factors that were there, because that is kind of the subject of the upcoming second part to the audio, and kind of where it went awry, if you want to know the truth. So the findings of fact and conclusions of law really did cut in the petitioner's favor, which would be Scott Peterson. They found that Rochelle Neese committed all the misconduct that she was accused of committing, but where that went sideways was that the court ultimately found that it was not prejudicial. And in reading through the document, there are several points that get very disturbing when you start to think about the leniency that's really given to the court as the fact finder to be able to take in all of this information and what seems logical. They are, it's their logic. Their logic is substituted for any standard of logic that you or I might have, and it can be frustrating. And in this case, it is. And I've said this before. I just feel like I need to restate it now. This isn't so much about the case itself, but about the proceedings and the findings themselves. It's a high-profile case. People have very strong feelings one way or the other about guilt or innocence in this case. But it's really about juror number 7. It's about Rochelle Neese. It is about, in this country, under our Constitution, all of us being afforded the right to have a full jury of unbiased and impartial jurors. And we arrive there through voir dire, through getting that opportunity through our counsel. If we're in a criminal proceeding, we're going to have counsel, whether it is court appointed or paid for by ourselves. I mean, sadly, it is also a system that very much favors, it's expensive. So it's going to favor those that have the means to get the best, Public defenders are super overworked. There's all kinds of issues that I hope to get into, in these Saturday discussions that are going to veer off of this particular topic. It's just one that I wanted to start with. So it really came down, to a set of criteria that the court is afforded. So there's a couple different ways in California that they arrive at these. And so I'm going to read you the list that's set forth in California law on how they determine if a witness is credible. Then I'm going to read you the substitution criteria that this judge inserted, okay? I'm also going to note for you that there was a delay. This order was supposed to come forth on December the 16th. It didn't ultimately come out until December the 20th, and that's because there were some issues that they had to get hammered out. So there's no question that it was kind of a, time crunch. But with that said, they actually did have a little bit of extra time. And what I find interesting is that when we got into the legal section of this document, it is where you find errors. It is where you find placeholders for citing case law. I counted 6 different places that both the clerk, the judge, everybody who laid hands on this prior to it being published and issued had missed, that they did not go back and do proper citations. And I think it's funny that it's all piled in to this section. And to me, that gives this impression that this was actually the more neglected area, which is a little fucked, because this is the meat. This is what we're in a courtroom for, right? So here's the criteria under California Civil Jury Instructions and the Judicial Council of California Criminal Jury Instructions. So CalCrim and Casey is the short versions of those. It's how well the witness was able to remember and describe what happened. What was the witness's behavior while testifying? Did the witness understand the questions and answer them directly? Was the witness's testimony influenced by a factor such as bias or prejudice, any personal relationship with someone involved in the case, or a personal interest in how the case is decided? Did the witness make a statement in the past that's consistent or inconsistent with his or her testimony today? How reasonable is the testimony when you consider all the other evidence in the case? Did the witness admit to being untruthful? Has the witness engaged in other conduct that reflects his or her believability? And was the witness promised immunity in exchange for their testimony? So these are the factors that under their own California law, they're supposed to be considering, okay? She instead substituted the following. So I'm going to say her in all of these because, of course, it pertains to Rochelle Neese. So she outlines in a footnote her actual criteria she used. Her demeanor while testifying and the manner that she's testifying, the character of her testimony, the extent of her capacity to perceive, recollect, or to communicate any manner about which she testifies, the extent of her opportunity to perceive any matter about which she testifies, her character for honesty or veracity or their opposites, the extent, the existence or non-existence of biased interest or other motives, a statement previously made by her that's consistent with her testimony at hearing, a statement previously made that's inconsistent, so same thing but on the other side of the token, the existence or non-existence of any fact testified to by her, her attitude towards the actions in which she testifies, or towards giving her testimony, and her admissions of truthfulness. They seem very close, right? And when you first look, it's like, but it's this first little indication, and it comes so quickly when you get, you've read, once you, with everything we talked about last week and everything that you can listen to in the first half of this document, that really just encompasses how we got here, why they were there, and the actual substance of this evidentiary hearing that they are ruling on at this point. It's a clusterfuck. and it's very sort of, here's what happened. It's very, recollect and just sort of the bones of what's about to happen. This is where we start to get into, the judge's portion of the program, if you will. And so to me, it's frustrating. It's frustrating because there's first this impression that I get that this was sort of a neglected area of the document itself. I can't speculate if that was a neglected area in thoughtfulness or not, but what it felt like ultimately to me as a reader, and when you get a chance to listen to the read through of this portion of the document, you can kind of come up with your own thoughts on it. But to me, it felt a lot like they knew where they wanted to go. They knew what they wanted the outcome to be, and it was about filling it in from the bottom up, which would explain why this top portion of the court's portion of the program is sort of neglected. And you're like, did you not notice before you published this for all the public that you have like literal spaces left waiting for you to go in and plug in some sort of law, some sort of citation, some sort of reference that you just sort of missed? It hasn't, I did check today, it hasn't been substituted. So what they published has never been substituted with some other revised draft. So for instance, if they had accidentally hit publish onto the, court website on a draft version of the order, they're certainly able to go in and supplant that with the final version that was entered in the courts. But that's not. This is the stamped, signed, sealed version, and I had to mention it because could be nothing, could be something. I just know how it left me feeling some type of way, so I wanted to put that out there. So when you get through that, and then the very next thing is this sort of substitution of what is usually used as the criteria. It felt weird to me, so I wanted to make sure to throw that out there. The law in this case comes down to whether it's intentional or not intentional. If a juror is omitting information, there is then it defaults to a presumption of prejudice. On both issues of juror misconduct through omission, through non-factual answering of the questions on the questionnaire and during voir dire, the court did find her statements to be false and thus indicative of misconduct. They found all of the misconduct elements in favor of the petitioner. But that's where it ends in terms of kind of reading through, and it felt kind of forced. I mean, one of the last things that they say, by the way, in the fact finding in this is for the purposes, blah, blah, blah. It's false, but that doesn't necessarily mean that it's untrue. And I'm just, I don't know. Okay. It gets a little wonky. The next fact finding, so you got, in regards to question 54. Question 54, you guys, is the one about whether she has ever been the witness to a crime, whether she, her family members, friends have ever been the victims of a crime. And so it was subsection A and B of question 54. And then the second one was whether she's ever been part of a lawsuit, and that's question 74. They had to tap dance around. Raymond, Ray trying to send a fax. Sorry, guys. Hold on.
No, he wants to go out.
That's all it is.
It's like, I need to fax my girlfriend. Oh my God.
Mm-hmm.
Bet he's sitting right outside the door like he was before. That's what he did before when I put him out. So on 74, you guys, the court had to walk through, and it just disturbs me. It disturbs me, you guys. And I can't pretend to be biased and or non-biased on this. I am. Okay. As soon as they pump into question 74, it gets harder for them to arrive. It's like begrudging. There's the word I'm looking for. It's like begrudgingly they have to say, yeah, she lied. Okay, she did. But in it, they're having to also break down the fact that Rochelle Neese first started with, I didn't understand what a lawsuit meant. I mean, I said no because I thought a lawsuit was just when you sue somebody for money or property. Well, then she got caught. She got caught because even if that was her understanding, she sued baby daddy's other chick for lost wages. She sued her for money. She dropped it, but she did do it. And so they had to get all around that. And they had to admit that. I mean, we're running into all these walls already of the times that she has switched up what she has to say. And then we get into what really mattered, So it's like those two things were very important, okay? Because that's what tells us, okay, so she committed misconduct. The court found that. Now they are going to parse down whether it was prejudicial misconduct. Even though the law has been set up to say it is presumed to be prejudicial, they turned this essentially into a case of actual bias. This court found a way to make this question morph into whether or not Rochelle Neese was, quote unquote, actually biased in these procedures. Okay. And they essentially, as you can imagine, arrive at that she was not. Okay. And so that's right away. So third fact, finding a fact statement was juror number 7 was not biased against this petitioner. And there's some problems with that. Okay. So there's a footnote there. I got pissed off and didn't read it halfway through. I'm just like, let me just give you the gist. And I'm going to give you guys the gist because it's weird. The first thing is that it's a little different to see a footnote put on a titling that is a finding of fact. The court is arriving at the finding of fact. So for them to put a footnote on their own statement, this is literally the sentence, you guys. Okay, so we've got, C, which is just denoting the section that we're in. Juror number 7 was not biased against petitioner. Footnote 36, just sitting right there. That's their title for this section. So I'm going, well, this must be a great one. I go down, I'm like, holy shit, this is the biggest footnote in the whole thing. What they do is they take the case. And this is where it's, this is where I feel like I'm back in law school, you guys. Like, petitioner relies on the case of Dyer versus Cauldron, and they explain this, right? They go in and they essentially write out the facts of that case of Dyer versus Cauldron. And then they distinguish it out by saying this isn't what happened here. Well, facts don't have to particularly match. Generally, there's going to be some piece of law that arrives out of it. And sometimes the facts might exclude this case or that case from the applicability of it. But this one, it's like a little more technical. And I'm just telling you that I was so pissed. I didn't even finish reading it. I'm just like, okay, you guys, what they do is they're hammering out the facts of the other case and saying that this one is different. The takeaway, though, of the argument that that Scott Peterson's team was making is that there is an implied bias that happens when you have a certain level of demonstrated omission. And it goes to the heart of this question that the judge chose to make this case about, which is whether there was actual bias. Because that's not technically what the law says. It's not technically what they're having to find. They're not tasked with determining actual bias based on if Rochelle Neese is going to say, yes, I was biased. They are allowed, and that's what this case was attempting to do, the Dyer case. The arguments that Scott Peterson's team was making is saying, if you look at all these things, she just conveniently forgot all these things. And they happen to be all the things that put her in a similar situation to the victim in the case that she is trying to sit before this jury, like on this jury, to pass judgment for. She had just given birth to baby 4, 2 years after she got a protection order. And only a year and a half before she sat in that courtroom to answer questions in order to sit on the jury of Scott Peterson. Every step along the way, she has said, it just didn't cross my mind. I just didn't even think of it. The domestic violence with her and Eddie Whiteside happened in 2000, okay? Baby daddy girlfriend, when she's pregnant with his first kid, okay? All of that happened in 2001. This is where, if you don't remember from last week, girl sprayed him in the face with mace, and he runs on over to Rochelle's house and comes in there, and here comes Miss Kinsley, like banging on their door, and if she's in there, fuck you, Kinsley just kicks in her door, and she calls the police. Not only does she call the police, but she also goes and gets a restraining order. Successfully gets the restraining order. Puts her child on that she's pregnant with at the time on the order. In the order, she goes on to explain even more that this woman has been driving around like she's seeing her, follow her around in her car. She's calling her home and hanging up on her. She changed her phone number. Somehow Kinsley got a hold of her phone number. You know, she's describing behavior that she even calls, quote unquote, stalkerish, right? But it's like stalker behavior. I mean, there's clearly some shit. But let's cut to it. One of the reasons that the court gives in minimizing this, what they're saying is that one of the findings of fact that the court issued is that she was not at all traumatized by any of these things. That she's being truthful when she says, I don't consider myself a victim of any, I've never been a victim. I wasn't lying when I said I wasn't a victim because I just don't consider myself that. So potato, you know, whatever. And the court says, yeah. I mean, she says it, and I think she's credible. So here we go. You know, that's what we'll take. The problem with that, and she says it just slipped her mind. 2001 is when she had the baby, middle of the year, okay? Is when she got a restraining order, pardon me. She has that baby. She gets pregnant again. And later in the year, in 2002, okay? So 2 years, almost 2 years later, she's having his second baby now. Baby number 1 shows up in a video at Eddie Whiteside's mom's house. And guess what? Side girl's there holding the baby that is still in this still active restraining order. And Rochelle Neese picks up the phone and calls the police and reports a violation. In the course of their investigating, They also found a second violation that had happened in 2001. Now, she said she could not remember it, and ultimately the team was not able to get the actual document from it. So it just kind of got thrown by the wayside. But I want to make sure to say that there is record, the face sheet of it. And we talked about this last week, but the face sheet of it made it in to their new like electronic system in East Palo Alto. But it's not the only instance of this. It's quite common, actually. For the older cases, when they transitioned over to the electronic systems, face sheets all made it in. So it's not like they lost a case anywhere or lost record that things happened, but the specifics, the handwritten notes from the officers that used to happen back around those times, you know, not all of that made it in the system. If it was an older case, it's like hit or miss, whether you're going to have backup documentation outside of just a face sheet that kind of says it happened and gives the, you know, numbers and things like that. But there were 2 times that this restraining order was violated, and 2 times, including 2 years later, she didn't have a problem remembering that she had the protection order 2 years later. But a year and a half after that, sitting in a courtroom for Scott Peterson, highly, highly, highly publicized case, you guys. And I probably don't have to tell most of you. I think all of us, you know, generally, you know, young demographics, not usually the ones that tune in to Mediocratics. So it's like most of us remember that, how big this case was. In fact, Rochelle was part of writing a book. Several of the jurors got together, wrote a book called We the Jury. And in that book, people discuss walking in the courtroom and it's like, holy shit, there's Mark Garrett. Oh my God, there's Scott Peterson. You know, these people had become like media fixtures. What does not ever get discussed in here, and again, this is where I'll say a couple things. There's a couple questions that she also lied on, and I don't know. Okay, this is where it's just wrong to do this stuff. Okay, fast forwarding to this, there are a couple questions she lied on, particularly number 72, that they never went back to for some reason. Cliff Gardner did not follow through with questioning, and so the court brought it up, but in the end couldn't say much about it. The other thing that happened, Eddie Whiteside spoke to Scott Peterson's team, but then dodged service. They were finally able to get him served, and the judge extended in order to keep them. But the thought, I'm almost sure the thought is that he's probably not compliant anymore. You know, so they were only going to bring him in to impeach. That was what they told the judge, is that we're going to reserve him. He has been finally served. We'll reserve him if we need to impeach Rochelle Neese's testimony. I don't know why they didn't do that. I have no idea why Scott Peterson's team did not pull him in, other than he spoke to them once and then he refused to speak to them and then he dodged service. So they probably knew it was like loose cannon. I mean, I can imagine there was some sort of calculated discussion on that. But in the end, they did not do that. I wish they had. Because what happens is that this judge was just sort of given the ability to filter everything through the lens of Rochelle Neese. I don't know that any judge that didn't want the outcome could have arrived at the things she did. I mean, she's okay. So for instance, she deems her credible. So I told you about there's nuances between the 2 sets, and she had supplanted one for the actual California standards. Okay. But here, let me tell you the reasons why. Judge Massullo says that Rochelle Neese is credible because her demeanor when she was testifying is appropriate, respectful, and catch this, you guys, was forthcoming. I know you can't see my face right now, but I'm just like, what? Forthcoming. Take a breath. Forthcoming. No. So she got caught lying. Okay. She lied on her questionnaire. She lied. She withheld during voir dire. That's more appropriate because there's been a couple things where it's like, oh, the lawyers didn't ask about that or this. Well, how would they? How would they know to? She marked no on a questionnaire. She lied. Okay. Or omitted because the law really doesn't care. You know, one or the other, pick it. You know, it's just if you have withheld something that's relevant. She talked to the appellate team in 2015. Okay. Okay. As soon as she found out she was at issue in the appeal, that the habeas would include an element that included her, she would not speak to them at all, ever again, since 2015, you guys. She issued a declaration in 2001, and in it got caught lying again. She showed up to this hearing in 2022 and pled the fifth. And it was not until the district attorney handed her that piece of paper that says, you have immunity, that she would even speak. But this judge has characterized her as forthcoming. Three different times when caught lying or being, being questioned. Okay, I'm gonna say that differently. When she was in a position where something she had omitted or not stated in her questionnaire was the basis of the question, she said over and over again, it just didn't come to me. I just wasn't thinking of that. When she was caught in what to all of us would be considered lies. Okay. Because it's, so I go back to our, part of what we talked about last week, which was Eddie Whiteside and the fact that she called the police on him in 2000 for domestic violence, but answered no to ever being the victim of any crime. That twisty turny turned into here in this hearing that, yeah, she had a bloody lip, but she thinks it's from her braces. He never touched her. Now, I'm not going to say whether he did or didn't. Who the fuck knows? I can tell you he pled guilty. And I can tell you that these, Scott Peterson's team, it didn't go on deaf ears because, of course, they say, isn't he the one who got taken away to jail that night? And she said, yes. Didn't he get a restraining order on him? Well, yeah, but I just threw it in the garbage. Wouldn't that say something about her thoughts about authority? And now here she is 20 years later saying, he never touched me. I actually beat him up. I beat him up. Wait. So you allowed him to get arrested from your home, not just for domestic violence, but she was pregnant. Again, she for like endangering her children. That was part of the charges. So she was asked, and you just allowed that to happen? You didn't speak up affirmatively for him, for the truth? You didn't say something? Now she can't recall. Oh, I don't remember what my thoughts were. I mean, Eddie didn't really tell me that much about what was going on. I mean, I guess I knew he had a case, but, and it's just she never could answer for that. And all of that seems to be getting put to the side. What my biggest thing that just drives me nuts, and it's not just at the judge. This is going to be at his team. You guys, we have on the record here a span of 4 years, including while she sat on that jury, that she is with a man who's having babies with her. And while she's pregnant, is out gallivanting, bringing to his mama's house the other woman. Hello. This is the Scott Peterson case where there is an Amber Fry, and where Amber Fry is cited as the turning point for most of these jurors. I'm telling you right now, you guys, they did not even discuss how this sort of relationship may have biased her. And it comes down to another question that I have, which is, in the end, this court took it upon itself to actually make, as a matter of fact, their opinion on whether she was actually biased or not. And their reasoning was really weak. Okay. Rochelle Neese was in like Newsweek, okay? A couple years after he was convicted and sent to death row, she started writing him letters, and they were crazy pants letters. Crazy pants letters talking about her little man. And, you know, and they were very emotional, and they did not look like a very emotionally stable person. All of these sort of things were just sort of blown off and left out of the judge's rationale. And it's not that they weren't brought up in court. They for sure were. They went a step further, too, by the way. They did admit a whole bunch of her child support documents because she was actually, Judge DeLucchi actually let her go because her employer was not going to pay. And because she was a single mom at the time of 2. Well, no, 3. She'd had her 3rd. And Mark Aragos wanted additional questioning. Now, the reason for that, you guys, is that her brother is in San Quentin.
Who was she writing?
She was writing Scott Peterson 2 years after she sentenced him to death. And you can Google those things, by the way. I'll find a link. I'll throw it in the description after the fact. But she started writing him, and it did. It ended up making it all the way into Newsweek. You know what I mean? And it's because they were kind of far out. You know what I mean? And it's not that people don't. I mean, I don't know how common it is. And, you know, it's a true crime community. You guys can kind of pop in if you know of any other situation like that. But for a juror, it doesn't alarm me as much that a juror might write the subject of the trial that they sat on. They've gone through that sort of thing together. I can maybe see where that could be something. But these were really like emotional, kind of scornful, and just felt a little extra. And enough to where a national news magazine is going to throw it in there and make a whole cover story out of it. And those did come up. And they did indicate that she herself had sort of drawn this parallel line between what he had done to his wife, to his child, and her own background. She drew those parallels. Now, the court went on to sort of, you know, again, everything had to be sort of swept to the side. And they did this by saying, well, that was after the fact. That's after she's heard all of the evidence. That's like, yeah, but it's evidence of the fact that she did walk in with a prejudice. She did have a bias she didn't disclose so that it could have been properly vetted. But what they cared about is getting to that end result. And what they said, what the judge had to say, it's a she, what she had to say was that those letters don't matter because that was after. She'd already heard all of the evidence. So after doesn't matter. And it does. And the legal standards had precedent saying why it did. Because they have to take all of it into consideration. Because this is kind of more about, no, I mean, she's not, think about this, you guys. Is somebody, are you even aware? Are we as human beings capable of having prejudices and biases that we ourselves might not even be consciously aware of. Right. Mm-hmm. Izzy, preach it. The answer is yes, we are. You know, we all have been molded in some way by our background, and not always are we going to be in a position to even be aware of that, right? So it becomes a real interesting thing when that becomes some standard. But more importantly, I think the thing that is so unsatisfying about the ruling is that they do a good job of laying out all the evidence, but then almost as quick, they throw the evidence out based on whether or not Rochelle Neese admitted she was a liar on the stand. Because, yeah, that comes into. Yeah, she's a liar, but she admitted she was a liar. Yeah, after she was given immunity. And then they call that being forthright. I disagree. It makes me scared. It makes me scared for accused parties in this country. And the appeals sector of things is a little bit different because, you know, it comes up in this, it'll come up in any appeal, any habeas. You're going to see it everywhere because it's true. There is a reliance and a strong value in this country put on the thought of finality in a case. And what ends up falling through the cracks are things like this, where I think the average person believes that we have a system that if something goes wrong, if something's just blaringly wrong, well, we get that on appeal. Well, we'll just appeal that. And every once in a while, you get a case, a high profile one, that illustrates for us that, no, that's not really how it works. And I brought up Brendan Dassey's case before, and I'm going to bring it up again because I feel like this ruling was just the latest Brendan Dassey-esque kind of example, but these happen in no-name cases every day. And it's why things like who is being appointed to the bench matters. Who we are electing as our judges, if we are in an area that we have that right and privilege, matters. And yet it's usually the afterthought. It's always the down ballot, you know, it has less percentage voting on it than our city councils and things like that. And it's unfortunate because they have so much latitude. And it's infuriating. And it's, you know, it takes sometimes maybe a case that you care about or that you get some interest in. Because like I said, there's plenty of people that don't care how this arrived at what it arrived at because, you know, Scott Peterson's guilty and he needs to stay here, there, wherever, you know. They're just glad it came out this way. So they don't view this as any sort of injustice because they're not really concerned about how they arrived there. And that's what I want to stress is that there's so little I can tell you about why the judge felt the way she felt in the end. And that's because there's so much given to the facts and the evidence that there is a problem. And it's almost like blindly everything defaulted to giving Rochelle Neese the benefit of the doubt. I mean, that's a way I can summarize it. That's the only way that makes sense. Every given opportunity, because she said this, then this. Because again, I'm going to come back to it over and over. This is a judge who considers the information that Rochelle Neese gave her finally in that courtroom in 2022, characterizes that as forthcoming. And to me, that's a huge stretch. I just don't even find that to be accurate. It's not, I don't know. That's like the last thing from forthcoming. That's like having to wrestle somebody down and they lie to you 5 times. And then finally they tell you the truth after they've been caught every which way but Sunday. And they finally tell you the truth and you call that forthcoming. It's just not forthcoming. Oh. Rose, she's part of the book. Yeah. Well, and they didn't let and there was all kind of, what I think about back because it was just this year, actually, this past year, so 2022, is when they kind of cut off public being able to call in and listen to these hearings. And until then, I called in all the time. So all through COVID, I loved it because you could just call in and listen to the hearings, and that's what I would do. So I could get the information myself. And right down to small things, you guys, like when they were deciding seating in the courtroom, okay? There was not a limit on how many of the Roachas and friends and family of the victim could come in, but they literally almost barred any more than 4 people coming in on the Peterson side. So it's like big rulings, little rulings. All along the way, I was hearing things that I'm like, yeah, this doesn't seem like a very this is still a judge that is part of the system. I mean, Judge DeLucchi passed away, rest in peace. Let me actually go. He made a great quote that I think is so powerful these days. And he made it in 2004. Okay. And this is on the family's website. It's got a picture of Judge DeLucchi. It says, with all the issues that have been raised in this case, if there's a conviction in this case, it will be an appellate lawyer's petri dish. A to the men. Okay. So there isn't a way to appeal what the Superior Court judge did in this case, but there are other options. Okay. So he can file a new habeas within 120 days from December 20th of last year. And that, according to Janie Peterson, his sister-in-law, that is what they're going to do. They are not, so the death penalty portion of the program, that is done. He will not be sentenced to death again. He's already been resentenced to life in prison. So he's actually not been transferred back. And he's still at Mule Creek because this is ongoing, but this issue is closed. This was it. So this is, you guys, like 2 decades of work. Okay. And in one ruling where the court didn't even fill in the citations in the legal, like the meat and potatoes of what mattered. This part's over. It's super frustrating. It's frustrating. Like, as an American, speak your truth. I mean, that's totally subjective, I guess. My answer is no. That's my opinion, though. I mean, my opinion is no. Because you had a juror who has demonstrated and concealed that she's been through some things that within the 2 years prior, and she was still in that relationship, you guys. So she's in a violent relationship, whether it's her towards him or him towards her, and now there's questions on the record, but what never got addressed by this judge is, okay, so then she's still in a volatile relationship with a man who cheats on her when she's pregnant. And that still mirrors the Scott Peterson case. It was a trial by media. I agree with that. And there wasn't a lot of evidence. That's like a whole different show, I guess. There wasn't a lot of, it was circumstantial evidence. And circumstantial evidence can be great, but it can also be scary because, it especially us in true crime, I think. I don't know anybody. I mean, I'm just going to bring this case up, but I don't know if anyone else, like during the Casey Anthony thing, I remember Googling, like, what does a dead body smell like? Okay. I don't know if anyone else is going to be brave enough to admit that they searched that, but I searched that. I'm like, because, it's like trash versus Kaylee, it's like, this was the topic back then. And sometimes some of us, that's just one example, but us that are into true crime things are like, deathly afraid if our Google history ever became an issue anywhere, right? And it's cases like this that make me think like, oh my God, there's some things that could be stacked up to look any which way. And it's like our hope is that circumstantial evidence will have some sort of backing somewhere. But when you're in a high profile case, it's all the more the media becomes this huge deal. And that's part of what I did research on when I was in law school, was particularly the Scott Peterson case and the influence of media in it. But that was not ultimately something that the courts found. They made this about Rochelle Neese. That was the issue. Even with, I read through, it is a 25-page questionnaire, but I re-looked through all of these questions they asked of the jurors, and I'm going to be fair and go back to what I was saying about her being with somebody who's chronically cheating on her while she's pregnant. It's a violent relationship, blah, blah, blah. There was not questions about infidelity at all on that questionnaire. Can you guys believe that? I can't believe that. That's just craziness to me. Because it was known by then that Amber Frey had done her tapes. And there was nothing. There was no questions on there that explored this. That's on Mark Garagos. Now, I'll remind people that Mark Garagos as ineffective counsel was listed in the original habeas, but it was not something that the court moved forward with. There were a lot of factors, but this was the factor that showed the promise. Now, there's been new evidence that's been found since the original petition around this issue that has survived up until the end of 2022 was filed in 2015. There has been new evidence found since 2015, and that is what the family is pushing forward with now. So they're going to, you can keep doing subsequent petitions at the state level. They do that for a reason. Most people want to stay out of the federal level, and there's good reason for that. If you are at all someone who's watched Making a Murderer, a fan of either if you think back to what Kathleen Zellner had to say in Making a Murderer 2 about how her personal philosophy, and she is the master when it comes to wrongful conviction, she really is. She would rather continue on with subsequent just state than ever to go in the federal system. And I know Making Murder 2 confused the issue because we watched Brendan go into that system, and for 2 seconds, and it was worse in real time. By the time that came out, most all of us that follow his case and feel strongly and are involved in that community already knew what had happened in November. So we knew. But it was like, even watching it and knowing how it came up, it's like, oh God, and knowing but that's going to get taken away from him. That was like, when they said a legal miracle, hell yes, that is. You don't see that ever, and even that got taken away from him because that's the power of the judiciary. So new evidence is where it's at on this. Cliff Gardner and the HCRC, they are looking at elevating this. Okay. And I can see why. So again, Crafton has to do some editing on the second half. I am going to keep the two halves of the reading of the document separate. But when you hear the second half, I think you'll, not the least of which is because I am not even a unbiased narrator. Okay. So even reading off the thing, you can pretty much tell where I'm getting pissed off. Okay. I don't play poker. I'm a bad poker face. He does have issues that he wants to elevate. I will tell you right now that I am not optimistic about the odds of the Supreme Court giving a shit about anything or wanting to touch a single thing having to do with Scott Peterson. Ever. Just like they refused to touch Brendan Dassey. Even though the Brendan Dassey case is ripe, it's overdue for the Supreme Court. That is about us that have special needs children, okay, special needs minors, and having some sort of guidelines and effect that make their, if heaven forbid they are ever called in to be interrogated, ever, that is about their constitutional rights. And I'm sorry, but our judicial system is officially political. And I don't think that they're going to take it. So I respect what Cliff Gardner's doing. But I honestly think there's a reason why the family is looking one way and Cliff is looking a different way. I'm so sad about the Brendan Dassey case, Octavia. And I do want to start talking about that too. And I'm working on that. We have people in our community actually who are very, very active in that community as well. And I didn't even know. So I was like, wow, cool. I started a Twitter only just because that I was like, I've been in that community on Twitter for a while. And so finding out that there's people, from that area, people that correspond with Brendan. I'm friends with his brother, his half brother, Brad. So I'm working on putting something together. Yeah. Rose, it was just horrible. Horrible. It was right at the holidays too. And it was just horrible. And then like I said, when the documentary came out, even though I knew this isn't going to stick, I mean, it was just such a, and then to see his family be so happy and, this has already happened. Like I already knew, this isn't going to happen, but it's like, you want it to, it's just too bad. And I've listened to all of the arguments and that's here on, YouTube. And I'll say before we kind of switch gears into another case, but just so it's out there, I'm looking at that case as well. Because there's so many different things to look at here. This is going to be ongoing, the Scott Peterson stuff. Kind of reminder, if this one is one that I will always follow, because while I was in law school, his appeals team was just getting started. And I actually did research on the media issues around it as like for credit, And so, I was in contact with Jackie Peterson before she died. It's just a sad situation, and I'm very aware that there's very strong feelings, and the general overwhelming thought still is that he is guilty, by most people. It's gotten better, but it's still largely, yeah, they don't care. Well, and I can say this. So Stephen, I don't think Stephen Avery's guilty either, but I'm not as freaking sure as I am about Brendan Dassey. Brendan, his own statements don't match the evidence, period. It's just gross. It makes me sick. It makes me sick because Brendan Dassey's case to me is the one that is so in your face that it's just the fact that they prosecuted it makes me sick. Just does. Well, and Rose, I might have a conversation just because I know it's like we're talking about the current appeals and things like that. But I know there's lots of people who feel very, 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 very strongly that Scott Peterson's guilty. And then there's lots of us that feel very strongly that he's not. I think Scott Peterson's an asshole. Okay. He's a weird dude. No getting around it. He is a weird guy. He is not someone that I would want any daughter of mine dating. Okay. He's got issues. There's no question. But he's not a killer. He's just not. Yeah, Rose. Yeah. Well, we know who used his computer. It's gross. Yeah. Well, and it's worse to think, listen, anybody who is cheating on their partner, I have feelings about anyway. Okay. Cheating on your pregnant wife, that we all have feelings about, right? None of us are gonna be like, oh yeah, that's fine, whatever. I think having Mark Garagos talking about it like it's like an everyday event didn't help anything. But being a cheater just does not automatically equal being a murderer. And in Scott's case, he had been caught cheating before while they're married, and she stayed, and she didn't say a word to anybody. So it was not unusual. It had been established in that relationship, sadly. You know what I mean? And that's sad, and that's fucked up, and it's dysfunctional. Okay. So there was some dysfunction already going on there. But, you know, I don't know. Do you go buy your wife a $2,000 Louis Vuitton wallet if you're planning to kill her? Do you tell the mistress, hey, I'm going to be out of the country for 2 months because he's actually planning to be home with his wife on Christmas and knows they're about to have a baby in late January, early February, and literally tries to stave off Amber Fry 2 months in advance? He tried to like cut her out of his life for the next 2 months. Is that someone who's about to kill somebody to be with that person? It never made sense. Amber Fry wanted kids. Amber Fry had a toddler. Like, none of it made sense. None of it made sense. And that's a whole different thing. But, you know, there's to know that even when it's something as cut and dry as our constitutional right to a fair and impartial jury, isn't enough. This wasn't about, overturning and he's walking out tomorrow. It was about a redo. It's about a trial that would have not had a Rochelle Niece sitting on that jury. We talked about it last week too, but I'm going to just remind people. They had a fellow juror, juror number 5, who was Justin Faulkner, who was dismissed about a couple months into the trial, about halfway through, who was prepared to testify and submitted in writing what he was going to testify to, because they had to fight to try to get him in. And in the end, this judge said no, because he can't be in my courtroom. He has to be here. Well, he works for our government. He works for the United States military. Today, he is stationed out in Iraq doing trainings. All he wanted was to appear via Zoom, and they said no. And part of what Cliff Gardner did to try to compel the court as to why this is important, like, I understand why you would like him, optimally, you'd want him to be here. But however, since our federal government is not going to give him the time off to be here in terms of flying back and all that, they'll give him time off to be here via Zoom. Perhaps the mistake is when he put in front of the court exactly what Justin and jury deliberation 3 more months after he was let go. He's talking about discussing what happened while he was there. So we're talking halfway through the trial, her as an alternate was already speaking about the case with other jurors, with him, a sitting juror at the time. There was already rumblings of a book deal. And he was going to testify about financial matters and her discussion and calling Connor little man, But those first two are really where it was at for me. Yeah, speak your truth. And there there's people that are very optimistic, I guess. I mean, I would say things like rose-colored glasses, but that sort of has a negative connotation, doesn't it? But there's some that, you know, and I say this because I'm from Jersey. Most people know that, right? I have very, very close friends who are literally like Italian, Catholic, and the values in that culture are very strong in their families, right? They don't leave their husbands, okay? And that's just my observation. It's what friends talk to me about, and it's kind of a stereotype that's out there, and to that I apologize, but it's because that's true in some cases, you know. And so that's just no different. There's some people, they would never leave their husbands no matter what. That's not a good or bad thing, okay? Because that can also be looked at as a sign of commitment, as somebody who is very eternally optimistic, right? And there can be other things that are a little more dysfunctional. Some people don't want to deal with the emotions that brings up. Either way, what is a known fact is that he cheated on her before, was caught, and she stayed. She not only stayed, she did not tell her mother. She didn't tell her brother. She did not tell people. That's on the record, you know. That's not going to happen, Cheryl. So his sister is graduating law school this year. Yay. So she is a 3L in law school. She, since the end of her first year, was snatched right up by the California Innocence Project. And she still works there. And so, of course, they're probably eagerly waiting for her to graduate and take the bar. I don't think Janie's going anywhere on this. And it's a fact. So he is still at Mule Creek. And it's been made very clear that they're moving forward with new evidence since 2015. Right. The unit staying together until the children are raised. Yeah. Well, and they tried real hard. They tried real hard to get pregnant. It wasn't an easy thing. But it's, you know, there was, one of the things was somebody saying, I don't know, you guys, the joke that was made at a cocktail party or something like that, where he had joked that he was kind of hoping on infertility. Who knows if that was that or not, but I don't know. I've said this before. I'll say it again. Scott Peterson hits me as somebody who is probably on the spectrum. He has very bad, his humor does not hit. It's just true. And that's from personal interaction. That's true, Cheryl. And I think, no matter what happens with him, though, here's what I have to say about Janie. Janie is very gifted in her passion and devotion to the law, and she's already working on other cases. And maybe that's good for her. You know what I mean? So while her brother-in-law's case is the one that led her into law school, I think it's great that she's working with the Innocence Project. Because once she's through with law school, takes the bar, she will be working on other people's cases. And I think other people will get to benefit from that passion, devotion, and intelligence that she has. I think Janie's a very smart woman. One of my best friends has forgiven her husband multiple times for cheating. Yeah. Oh, that's tough too. I can't imagine that the outside children. That's what I mean. It's so personal. Like, no, that's where it's like none of us have the right to tell people if they should leave or if they should go. I know for me, like, especially when I was younger, I used to be like, oh my God, if someone cheated on me, I'm gone. It's like, and that's like what we'd like to think, but it's not always that simple. And I think the older we get too, it's just kind of like, it's hurtful. You know what I mean? Even the ones that stay, That's where I want to make some concessions too. Whether Lacey knew or didn't know, that's hurtful. Can you imagine? I mean, that's not a good feeling. That's why I said he's an asshole. He's a piece of shit. I wouldn't want my kid, you know, if I had daughters, no way. You know, there's some people that are like, oh, fascinated with Scott Peterson. And for a while, if you thought anything about his case, by the way, for many years, especially those early years, you automatically must be like infatuated with him, want to fuck him, whatever it is. Like if you were a woman who supported Scott Peterson in any way or believed he was innocent, that was automatically the stereotype. Listen, I think Scott Peterson, I do not think he's attractive. I think he's kind of twerpy. And I think he's like a really not decent human being. I just don't think he's a killer. I think he's a liar. I think he's a cheater. I think he's insecure. I think he's not incredibly charming or funny. You know, he tries to be a lot of things that he's not. And he was pampered. I mean, he was coddled. It did not work out for him. You know what I mean? He's a narcissistic cheater. Amen, Rose. Thank you. That's a way to put it. You know what I mean? Most narcissists, by the way, we think of narcissists in this sort of overt, whatever way. Most narcissists at their base are insecure people. Oh my gosh, that interview. The Memphis Mama, the behavior panel, I don't know if you watch them. They covered, if you look up the behavior panel, you know, Scott Peterson, they used the Diane Sawyer interview, and I died laughing. Yeah, his mom did spoil him. Well, his mom had given up a lot of children for, you know, had given up kids for adoption. Jackie was a complex woman, but she, you know, she loved him. She really did. And she, you know, she loved Lee, you know, her husband. So it's like that was their child together, you know, so that he has a lot of half brothers and sisters. And, you know, so that, but he was in some ways like an only child, you know, he had much older half siblings and things like that just doted on him. He had a whole family that doted on him. That's what it came down to. Yeah, it's true though. All right, you guys. Well, I'm going to open up the panel. I don't know. Does anybody want to come up and talk or give their opinion on this? I'm going to finish my read through and get cracking on editing it together. Well, and that's the thing too, is it's sad, Rose, no matter what, because it's like, you know, Connor never got to be born, like whatever happened, you know, Lacey's not here, whatever happened. People that feel very strongly that he did it, they actually, you know, I sort of envy them because they don't think of the other portion that stays on my mind, which is imagine if you're just the piece of shit husband, okay, because he was a piece of shit husband, but he lost his whole family and is sat in jail. When people talk about, well, he's off death row, he would have never been executed. It's California. That's it. There's no difference, really. I mean, San Quentin sucks. That's true. But jail's jail. It's not like one's better than the other. I think he was really used to death row, too. So it's like when he goes back, it's, you know, there's not a lot of win in the loss, you know, in the death penalty getting thrown out. Not in his day-to-day life, anyway. Where are you headed, Rose? Did I miss it? Sorry, you know how it's like hard. I hate it when I'm like the speaker because then I don't even read chat until the unexpected trip. So you're Wait, are you going to? You said you're going to Memphis? That's going to be there's going to be a lot of people there. Go get your order, Memphis Mama. Yeah, Cheryl, I don't think he was all that into Amber Fry. I'll be honest with you. I think he clung to her when things got really public. You know, that's like what he had. You know what I mean? I think it scared him more having nobody. The Ozarks in Kansas.
Arkansas.
Oh. Oh. That's cool. I know. I can't believe it. Aiden couldn't believe it either. It's crazy. That's how we started the show, Rose. It was like a little second for Lisa Marie because that's just, I don't know. So close. I mean, it's just so close. I mean, it was only 2 years ago that Ben died. It's a lot. It's a lot. Oh, good. Send me pics. Yay. All right, guys. Well, I will not drop the link then. I'll save the open panel for when I'm on time next week. It's Aiden's last night. Well, no, he'll be here tomorrow night too. I have to take him back on Monday.
Last Sunday night.
Yeah. He's going back to school. He was home for like a month. It's going to be weird with him leaving again. It really is going to be weird. It's going to be like getting used to it again. It's been so loud and messy and stuff around here, and now he's going to be gone again. Lord help me. Well, we did. I don't think they have an outcome just yet. I did hear that that some things changed, though. Not all the witnesses that were going to appear got called. So there is not an outcome to report just yet on that, Octavia. All right, guys. Well, have a good rest of your Saturday, and I'll be on sometime here in the next couple days anyway, because I have other things to talk about. And I had intended to do a live, but like I said, I'm probably going to wait for Aiden to go back to school so that I don't use up my last little bit of time with him for this. No, they just don't have an outcome yet, Octavia. So there's nothing to update on yet. So, all right, guys, love you, and we'll see you next Saturday, if not before. See you around the tubes.
You hitting the end?